So today we're going to talk about courts and alternative dispute resolution. How much do you think attorneys make an hour?
The book said $100 to $600 an hour.
Yeah, I mean it varies greatly, but you know, I would say that if you can find an attorney for a couple $100 an hour, that's pretty good. So if you think about what it costs to see one, have them prepare pleadings, attend all the hearings, select a jury, have a trial, and then represent you on appeal if you're not happy, that can be very expensive. In the many thousands of dollars if you end up having a trial. So the rest of the chapter talks about other ways of resolving disputes. So here are some of the concepts that we're going to look at today. The concept or idea of judicial review, jurisdiction, which means something a little different than what you think it might mean from TV, the trial court and appellate court process, some of the things that go on during the trial like discovery, and then alternative ways of resolving disputes. And probably some of you have heard of Marbury versus Madison before in government class or some other class. But that's where the Supreme Court solidified judicial review and basically said, to paraphrase, we can look at the other branches of government and determine if their actions or the law that they create is constitutional or not. At the time, the other branches said, keep your nose out of our business. We create statutes. It's our problem if they're messed up. Again, paraphrasing. But the Supreme Court said, nope, it's part of our job. It's how we're supposed to be set up. It's within our province. And speaking of the province of the court, there's this idea of jurisdiction. And as it says, it really means the power of the court to speak the law. A lot of times on cops, what's jurisdiction? Right, where they have power, the police have power to chase people and put their boot on somebody's throat or something, right? But here it's talking about the courts and what power they have. And, you know, basically, certain courts are set up to hear certain kind of cases. Other courts hear a variety of different types of cases. So, from reading the chapter, if you have a bankruptcy case, where do you go? Bankruptcy court. Makes sense. Where is the bankruptcy court? Is that in the state court where the citizen is at, or is that in the federal court? It's in federal court, in the bankruptcy division, U.S. District Court. So they're set up by name to have jurisdiction over those kind of cases. So jurisdiction means if you went downtown to one of the state courts and said, I'm broke, I can prove it, they should say, sorry, wrong place, go to the federal court system. Even if they listened to your case and they said, you're the brokest person, I don't know if brokest is a word, but you're really sad, you've got no money, I declare you bankrupt. What legal effect would that decision have? Nothing. You'd go around showing people a state court order saying you're bankrupt and they'd just laugh. It's not of any legal effect. So you go to the right place and you get a decision, and that decision is legally binding on the parties who were involved in that case. That's important too. It's not supposed to be legally binding on other parties who are not part of the case, who didn't know about the case. All right, and to have jurisdiction, you need a couple things. You need jurisdiction over the person. You got to let them know that there's something happening to them or their legal rights. Obviously, if you're the one complaining, if you're the one that go to the court, then the court has jurisdiction over you, right? You go there and you say, court, you're the right place for me to be. I want you to give me a remedy. Remember that from chapter 1, a remedy? So this is the other party. And they should know that something's happening to them. What's that called? That idea that you should get notice, an opportunity to be heard, fair and impartial judge. Due process. These things are starting to link together. So that's why we put chapter 1 and 3 together on the quiz, and they're really foundational to the rest of the course. Personal jurisdiction is also called in personam jurisdiction. The power of the court to compel a person to be in front of them. If you object to a jurisdiction, you're like, hey, I've never been in your state, you don't have jurisdiction over me, then it's a bad idea to go to the court and do that. Guess what happens if you stand in front of a judge and say, you don't have jurisdiction over me? They say, you do not? I do now. You're right here. There's nothing that's going to happen to you you're not going to know about because you're standing here. So you send an attorney to say, my client doesn't feel that you have jurisdiction over them. When I say persons, that can mean a corporation too. Okay? So, and that's in business law, we're talking a lot about businesses that are within the state or some other state and whether they've had contact within a state. Notice the last word, litigate. Litigate means to have a lawsuit. So in the end of the chapter, we'll talk about alternative ways of resolving dispute. But if you see that term litigation, that means the trial, the lawsuit. The other thing you need, well, this is like related to in personam jurisdiction, is if you can't get a hold of the person, maybe you can get a hold of their stuff here. Think about that in terms of corporations. If corporations had property here, or somebody used to be here, but you can't personally serve them or get a hold of them, but they got stuff here within Michigan, then Michigan courts would have jurisdiction over that stuff. Right? It may not do that much good to have jurisdiction over a person if what you really want is their assets anyway. So even if a person isn't within the state or the corporation isn't within the state, if they have property within that state, within the geographical boundaries, then the court has jurisdiction over that property. That's called in rem jurisdiction. So first part of the equation, get jurisdiction over the person or their stuff. What's the other part? What's the other thing you have to have? You have to have jurisdiction over the subject matter, right? It's not enough to have jurisdiction over somebody and serve them if you're in the wrong court. All right, so we'll get to that in a minute. Sometimes it's a little trickier. Like people you want to sue aren't standing within Michigan. They're somewhere else. Or the corporation that you bought the product from, or the product that harmed you, the corporation is in some other state. So there's what's called long arm statutes. Anybody heard that expression, a long arm of the law? Right? Michigan courts able to reach out past geographic boundaries and bring somebody outside the state within their jurisdiction through statutory law. Statutory law is created by who? The legislature. So, in order to get jurisdiction over parties, people, or corporations that aren't within Michigan, you would need to establish that that corporation or person had certain minimum contacts within the state. Even if they're not here now, they've somehow contacted somebody inside the state. So if you're suing over a product that harmed you, what would you argue under the long arm statute? Right? Because they want you to go there. Right? I mean, it'd be awfully inconvenient for them to have to come to you for you to sue them. So how do you get just jurisdiction over them if they're somewhere else? Prove that somehow the product was sold here and injured you here. Isn't one type of minimum contact would be a product that makes contact with you and injures you, right? So you say, look, I realize you're there and you sold me the product here, but I'm here, I was injured here, you come here. And if the court determines that there's enough minimum contact, then the court will exercise jurisdiction and they better get to Michigan. So one way of doing that is showing the product injured you. Maybe they do business here over the internet. Maybe they advertise here. Maybe they have salespeople here. Maybe they have a factory here. Whatever it is, you have to establish that even though they're somewhere else, they've been here enough that the court can exercise jurisdiction. What would not be sufficient, you think, for the court to say that corporations had minimum contact within the state? Does it feel like Monday even though it's Tuesday? I thought it was, I thought you were my other class. What would not be enough to satisfy a long-arm statute? No contact, right? I mean, one thing is just saying, look, Judge, we object. You've got no jurisdiction over this because there's no way you can establish you've ever been there, sold anything there. We don't know why they're suing us. And if they want to sue us, they better come to us because we haven't been there. Or just that whatever it was, maybe it's a web page on the internet. I mean, isn't there a difference between e-commerce site where you can buy something and just a web page that says we're XYZ company without reaching out and selling you something?
Is it an advertisement though?
It is, but I'm not sure, absent some ability for you to buy the product, it would be enough. I mean, aren't there things on the internet that are sold but you can't buy? And they won't ship them to you? I don't know, sometimes they will, but what if they do advertise a product but it's illegal to have in your state and they didn't ship it to you? Right? So you get injured by a product, but they didn't sell it to you. They had nothing to do with it. So then it becomes the question. Sometimes these things can be a little tricky. Yeah?
The long-arm statute, though, doesn't go outside the U.S., right? There's companies based.
There are other laws related to jurisdiction internationally, but long-arm statutes are by state. Yeah. So, if I can anticipate where you're going with this, well then, what if the person who sold you the product wasn't within the United States? Can you get a hold of somebody who's somewhere else? And that's why we have international law. That becomes the question. And really, without going into a lot of detail on it, what usually happens is countries who have laws like ours and we have a good relationship with, usually that works out. If not, not so much. So sometimes it's important where you buy your products from. All right. And we mentioned corporate contacts, and it says up there, if it's in the stream of commerce or there's active advertising, which I defined as more than just a website with a picture on it or a name on it, some way of soliciting or saying, you can buy this product from us. All right, so here's the second part. Jurisdiction over the subject matter. I mean, hopefully you can start to see this. If I'm a plaintiff and I complain about somebody, what's the very first thing I'm going to say in my complaint to the court? I'll give you a hint. It's on the slide. What would I tell the court? You're cool and groovy, court. I like you. Hear my case. Wouldn't you say, hey, court, you have jurisdiction. I'm here talking to you, complaining to you because I think you're the right place to be. According to this statute, you've got the power. And whoever I'm suing is within the state. So you have both subject matter jurisdiction and jurisdiction over the person or corporation. Could one of you close the door? Thank you. Or, hey, court, You're a federal court, you're the bankruptcy court, and I have a bankruptcy claim. So you want to say that first, because you don't want to get involved in the trial and then go, ooh, whoops, I screwed up. I guess I'm in the wrong place. Right? So you want to let a court know that first thing. As I mentioned earlier, some courts have limitations on what kind of cases they hear. Family court, you go there for family matters or bankruptcy. Other courts might hear both civil and criminal cases. The circuit court in Michigan hears a variety of different types of cases. They even hear some appeals from the lower district court. But if you've got a felony case, you end up in circuit court. If you've got a civil complaint over a certain amount of money, you end up in circuit court. So they hear lots of different types of courts. I mean, think about the different judges you need. One judge, bankruptcy judge, what do they need to know? I mean, they need to know some contract law, corporate law, some things like that. But bankruptcy, what they do day in and day out, versus in the circuit court, they might have a variety of different types of dockets that they actually hear. All right, those courts are general jurisdiction court. Unlimited is probably too broad of a word. You know, that doesn't mean they can hear every case, but they're not limited to a specific type of case. Right? So, if you have a case and you can go to all these different courts, what might be one of the first things you do to determine which court's the right court? See a lawyer. Exactly. Because that's what they do, right? And, oh yeah, try going to a court clerk and saying, is this the right place? Or am I doing the right thing? There's a big sign that says, don't ask me. Right? Because people ask all the time. They walk in. Some of them are more helpful than others, but don't get your legal advice from another business law student. Don't get it from somebody wandering around in the courthouse. You know, if you go to an attorney, one of the first things they're going to do is investigate the facts and the law and find out if your case should be in this specific court. If they end up in the wrong court, that can be malpractice on their part. Hopefully they'll know that bankruptcy is in the bankruptcy court. Others are a little more complicated. I mean, think about this. Let's say there's a lady walking in Florida, and along comes a truck from Texas. Something falls off the truck, hits her in the head. She's from Michigan. She goes to see a lawyer in there after she gets out of the hospital. Which court is she going to sue in? Florida, because that's where she got hit? That's where she's at? Maybe. I mean, she's from Michigan. She doesn't know anybody there. She was just visiting Disney. So she wants to go back to Michigan, right? Where else could she sue? Texas, which seems weird. Why would a woman who's from Michigan who gets injured in Florida sue in Texas?
Insurance is covered by the guy driving from Texas.
Yeah. Well, that might be true everywhere, right? I mean, if somebody's insured to drive all over the place, then you may not necessarily have to go to the state of whoever is protected to sue them. But there's a more basic reason why she might.
That's where his company is.
Sure, that's why that court would have jurisdiction, I think. But why is she going to Texas when she's from Michigan and she got hit in Florida? What? Exactly. She might get more money or she might get it faster, right? Maybe Florida has a cap on personal injury cases. And their lawyer says, well, you can sue here. This court has jurisdiction because you got hit right there in that street. But I got to tell you, when I look at the law and your injury, you're capped at $1 million. Right? But if you go to Texas, they do it big in Texas. You know, I'm just making this up, but you know, there's no cap, personal injury. Michigan, that might be convenient for you because that's where you're from, but right? So, and that doesn't necessarily mean she's got to go there every day, right? She can get legal representation there, somebody who's licensed there, and work through those court systems. So it can be a little more complicated than where is the plaintiff at right now. But insurance, yeah, insurance is an important thing too. All right. Another way of looking at jurisdiction is original versus appellate jurisdiction. When I say original jurisdiction, I mean trial court jurisdiction. Original jurisdiction is where you first go to try your case. They're the ones that are going to hear the facts, apply it to the law, and render a decision. Appellate courts do what? Hear appeals. That's all they do, right? If you go down to the Michigan Court of Appeals, there's no jury box. There's no lawyers introducing knives into evidence. There's no witnesses testifying under oath about things. Basically, they do what? Review. Exactly. Here's the lower court record. Here's the briefs of the parties who are arguing the judge properly applied the law or didn't apply it, and they just say yay or nay. We agree, or it needs to go back. If we agree, it's called affirm. If they send it back, that's called a remand. They might send. Well, why might they send a case back? Yeah, they're not going to guess at things. They're not going to interpret the facts. They're going to send it back if something's missing. The lower court didn't do their job properly. Or they could overturn it. We got everything we need. We've got the record. We don't need any more evidence. And here's the law that we've decided previously. You did not follow it. So we're going to reverse the decision. If you're a lower court, you'd at least like the chance to get it remanded and fix whatever's wrong, but it doesn't look good on your scoreboard if you get reversed a lot on appeal. All right, so lower court finds facts, apply the law, reaches a decision. Appellate courts pretty much taking a look at the legal aspect of the case, not so much the facts. Here are the facts as determined by the judge or jury in a lower court. Here's how the law was applied. Was it applied correctly or not? And it could be any decision that the lower court made. Decision to not allow a witness, or not to suppress evidence that should have been, or improperly applying case law. All right. One way to get to federal court is to have a federal question. A federal question could be a U.S. constitutional claim or some allegation that somebody violated federal law. So don't let this be a trick to you. If I said to you, cases involving federal law go to federal court, that's not intended to be tricky or anything. If it's federal law, federal court. If it's a U.S. constitutional claim, somebody can bring it in the U.S. or federal court system. Sometimes there's different claims, like you could have a violation of federal constitutional law and state law. And then there's the other way you can get to federal court, through diversity. Don't let this one trick you either. Diversity involves parties that are not from the same state and a dollar amount. So it's not enough that you're from Michigan and someone else is from Texas. It also has to be greater than $75,000. The feds don't want to mess with nickel and dime cases. So, can't you see a scenario that I would come up with, right? Like the scenario I already gave you, right? I've talked about how you could be in Florida State Court, Texas State Court, Michigan State Court. Now it's even more complicated because of what? You could also be in a federal court, right? Because there's diversity of citizenship. I told you, one party's from Michigan, the other party's from Texas, and I didn't tell you the dollar amount, so you'd want to know, was the head injury in excess of $75,000. You're a accredited attorney, you've got all the medical bills, time off from work, plus emotional distress because she flinches now every time a truck goes by. I don't know. But it's going to add up. So you've got lots of choices. Again, why would you want to be in the federal court system versus the state? That's why you see an attorney, right? Are the rules of evidence more relaxed? What will I be required to do? How expensive it's all those things are going to come into play. Is the law more favorable to me or the other party? So, don't forget about those different ways you can end up in federal court. And the flip side of this, I'll say it and I say it again, if it's purely a state issue, doesn't involve diversity of citizenship, doesn't involve any type of federal question, it goes to state court and it stops in state court. A lot of people believe the U.S. Supreme Court can hear anything that it wants. It doesn't have the somebody help me. Jurisdictional, thank you. Power to hear purely state claims. It's got plenty to do already. Right? Hear appeals from the federal court system. Hear important U.S. constitutional claims. It can't sniff around into every state and try to figure out if some state statute's being violated. Now, of course, you're an attorney and somebody comes to you and says, I need to be in the federal court system, but I have violation of a state statute. You're probably going to figure out some federal claim, sure. But if you ever see a scenario where it's purely a state issue, the U.S. Supreme Court is not getting involved in that, except Bush versus Gore. That was supposed to be a Florida case, and they got involved in it. So, didn't I say the answer is usually it depends? All right, so sometimes it's not so clear, like the example I've given you about the woman who was hit by something falling from the truck. There could be concurrent jurisdiction. More than one court has jurisdiction at the same time. So far we've been talking about, do you go to state or do you go to federal, and which state court do you go to, but in some cases you might have the opportunity to go one way or the other. So there's concurrent jurisdiction when you bring both a U.S. constitutional claim and Michigan constitutional claim, or if there's diversity of citizenship. In other cases, what page is this on in your chapter? All right, so if you're in the blue, exclusively federal. We mentioned bankruptcy, right? If it's a federal crime, it falls under a federal statute. Most people don't know intellectual property. If you're alleging a violation of a copyright or a patent or something, you're going to federal court. Or it could be exclusively state. No federal jurisdiction involved. Purely something like an adoption or divorce. No federal statute involved. No intellectual property claims. So some cases it's purely state. Sometimes it's exclusively federal. Other times it's concurrently in between. All right. Because the authors want to make the chapter relevant to today, we have to talk about cyberspace. Does anybody say cyberspace anymore? Hey, I was on cyberspace today. I'm going to start saying that just so people can look annoyed at me. Did you check cyberspace for Blackboard today? So, so far we've been talking about you're in Michigan, you're subject to Michigan court jurisdictions. You're outside of Michigan, if you have enough minimum contact, you're subject to courts. That's all about where Michigan begins and ends, though. In cyberspace, on the internet, online, it's a little fuzzier. There's not state borders, boundaries. When you buy something, it could be from practically anywhere. So the courts have adopted this sliding scale in terms of looking at whether there's been enough minimum contact with the state through cyberspace to give the state's court jurisdiction. Did you see it was a sliding scale? I don't know if you saw that slide there. Everybody see that one more time? So, like I mentioned earlier, a title and a picture of the product, no more. Fairly passive. They're not aggressively, or they're not even saying you can buy our product. On the other end, e-commerce. You go to their site, you can buy their product. Some sites are pretty open to purchase from anywhere. All it takes is a click, right? Go to Amazon.com, all your stuff's in there, click a button, you got it. They've opened up themselves up to jurisdiction for any state. All right, venue. Venue is a lot like what you see on TV. Venue has to do with the appropriate geographic area for the case to be heard. So let's differentiate jurisdiction from venue. You have a bankruptcy case, but there are bankruptcy courts all over Michigan. There's one on the east side, west side, northern, southern, right? There's all these different districts. So why would you go to one of those courts over another? Like, right, where you are at, where your corporate assets might be at, maybe even where your creditors are at. So the Western District of Michigan might be a convenient geographic location. And the court might even say, what are you doing over here? All your stuff's over there. Most of your creditors are over there. You should be there. So convenience of the court or the parties is certainly one thing to look at when you're talking about venue. You probably hear about venue differently, right? Venue comes up a lot in criminal cases where people say, they don't like me around here. I won't get a fair trial. I want to go to a different venue. Which means multiple courts may have jurisdiction over this case, but they want to go somewhere where they're going to get a fair shake. So most appropriate might have to do with the fairest place. What kind of cases have you heard about where people have argued, I won't get a fair trial here, I want to go somewhere else? You can't get this on the recording. They're all holding up their hands, dying to answer.
Murder cases?
Right, dying. Yeah. What was that guy? Scott Peterson? Remember the guy's always dyeing his hair, running to Mexico? You know, he chopped up his wife and unborn child, and then he's like, oh, people don't like me. So he wanted to go get tried somewhere else. Remember the Oklahoma bombing case? Timothy McVeigh and what was that other guy's name? Anybody remember that case? Were you guys around? Timothy McVeigh and Terry Nichols. You should remember Terry Nichols. He's from Michigan. Good old Michigan militia guy. Right? So McVeigh gets executed. Right? And then Terry Nichols gets life. Well, then later he brings a motion for a change of venue. Right? We just got through saying that venue is something where you argue my trial should be somewhere else. Why then, after he's spending life in prison, is he bringing a motion for change of venue? Well, if you think you got a bad deal, then you appeal, right, for a new trial. But why would you ask for your trial, which you've already had, to be somewhere else? Does it make a lot of sense? Well, what happened is they originally prosecuted both of them under federal law. And when they did that, the defendants asked for a change of venue. Why did they want a change of venue? They didn't think people would like them in Oklahoma City. Besides, there was a logistical issue with having the case tried in the federal court building. It wasn't there anymore. But also, there's something that they can do to you in federal court that they don't do to you in some states. Right, kill you. So they were concerned about that risk. And they eventually did get tried and convicted, like I said. And Terry Nichols was asking for a change of venue because he was getting tried again. He was tried a second time for killing state citizens in Oklahoma. Prosecutor went after him the first time under federal law and figured if he didn't get the death penalty, he would try again in another case. Yeah.
What would be the point? Like, I watched a lot of trial cases and stuff, and like, if they're in there for life, what would be the point I'm trying to, or get, like how they get charged for another crime when they're already in there or whatever. What
would be the point of that? Well, in that case, federal employees were killed in a federal building, and people were pretty upset about. But what they were really upset about is the state citizens and the children who were in that building. And the prosecutors were like, we're going to get the death penalty. We're going into federal court. And if we don't get it, we're going to go again against different parties. So it's expensive. And to some it may seem, what's the difference between life in prison and death? But to the people who, had to go through that, that's why they. Yeah, that's what the defense says. I would tend to agree. I mean, why not bring an action on behalf of all people killed in the building at one time? So that's why. So I mean, when I was a prosecutor, I'd get letters from people saying, "I'm serving time in this prison. I killed somebody up there in Michigan. Here's where they're buried. Here's how I did it. Please bring me to Michigan and prosecute me." And you might ask, well, then why, if they are there in prison, would they want to come here to Michigan and confess? Because they're on death row and they're in a state that's going to kill them, and they want to come to Michigan where we don't. So they get just enough information from the newspaper or from cellmates to say, "Oh, I did it."
Even if they actually did that, to actually try and go through with that time after
No.
time that they're serving time for?
No. No, it's not like, if you did something afterwards. I mean, if you are alleged to do something while you're in prison, that's a pretty decent argument that you were somewhere else at the time, but unless it's somebody in prison that you killed. But the flip side is, no, I don't think there's no statute of limitations or rules about you being prosecuted for killing somebody just because you're already serving for killing someone else.
So you've got the case right now with the guy from Flint that supposedly killed the people in Flint, Ohio, Virginia, whatever. Who has jurisdiction? Michigan?
Yeah, it depends. I throw that out every time I don't know the answer, but also because the answers aren't always that easy. I mean, we've talked a little bit about how multiple courts might have jurisdiction. I mean, think about any case where somebody kidnaps and goes through many states. Now they've violated federal law, they've violated every state's law. Who wants them? Sometimes the question is, who's got them? Right? Because if you got them and someone else wants them, they want to extradite them to that state, and you're like, not until I'm done with them. So, but sometimes it's like, well, let's all get together. If we keep them here in Flint, this is what we can do to them. If we take them here, this is what we can do to them. So yeah, it depends. All right, standing or standing to sue. You got to be the right party to bring the lawsuit. You sue because you were injured. You're not suing because you heard somebody else had a bad time. Right? You come into class, you're like, I say, how was your weekend? And you're like, oh, it was horrible. This happened to me. And I'm like, that's horrible. I'm going to sue for you. Even being an attorney, I would be representing someone else's interest, not my own. I can't recover money for your injury. So being the right party to sue is part of standing. It's not the only part. You also have to have a real case. So it's not enough to say, well, this might have happened to me. Let's say I'm going through the drive-thru at McDonald's, and my kids want the toys, right? And I go to give my kid the new, I don't know what toy it is, but I look at it, I grab it, and I go, they could have choked on this. Can I sue for that? The fact that they could have, at some point in the future, got a hold of that, and there was no injury, right? So you got to have to both parts. I mean, I could sue on behalf of them because they're my kids, but nothing happened to them. So you got to let them choke first. No, that's not what I'm trying to say. I'm just saying that there's no action until something happens. Now, there could be sometimes a threat of harm is enough, right? I mean, if I threaten to kill you, then the fact that you've suffered a threat, even though I didn't actually kill you, is enough. But if you just looked at me one day and said, you know what, you could kill me, that's not enough. So you need two parts. You have to be the right party, and you have to have a actual controversy the court can decide. Courts just don't run around saying, that That's too bad that happened to you. I wanna hear your case. You got to bring your case to the court. Yeah, let's not go into that. All right, state court systems, and they use Texas in your book as an example. And I would say just say state court system. It doesn't matter what state. The thing that's different in some states is what they call the courts. So like in New York, you'd think the Superior Court was the superior top court, but it isn't. So don't pay a lot of attention to the names. Know that there's 3 levels. There's the trial level. There's an appellate level, often called the Court of Appeals. And then there's some highest court within that state system. That's what you have to know. If you have a U.S. and state claim, maybe you go further. If it's purely a state claim, then you stop at the top, whatever that court's called. In Michigan, it is the Michigan Supreme Court. And I'm going to go into more detail to these, but this is pretty much, if not the sequence, the major parts of a trial in a state court. You go to the right court, there's a record. Now, every case, like small claims, traffic offenses, every case is not recorded and then put in reports for everybody to read. There's a record of it of some kind, but only more important cases are actually reported in cases that attorneys get a hold of and look through. They start with opening and close, or they start with opening arguments, close with closing arguments. They include selection of the jury, which we'll go into a little more detail into. On TV, there's always the surprise witness, but in reality, there's an introduction of evidence by all the parties, and the parties could ask what evidence is going to be introduced at trial before the trial. Witnesses are examined and cross-examined. If it's a jury, it's called a verdict. If it's a judge, it's a judgment. And there's different standards in terms of how many jurors you need, depending on what kind of case it is. Again, there may be some difference state by state in the appellate court process, but this is pretty much the way it works. They're in the middle. They're hearing appeals from lower courts. They basically review the proceedings of the lower court and make sure that it complies with procedural substantive law. And as I said earlier, they're not concerned with questions of fact, usually. Yeah.
You said it was 3 levels?
Yes.
For the Texas court, that's not, because we hear the statement is 4.
Well, yeah, I mean, what I said was not all states are the same. And even in Michigan, I could have a diagram where I have small claims court below the trial court, the district court, etc. So
I'm saying, did you just talk about Texas court?
No, I'm talking about the general levels, because even though they say there's 4 levels, that 4th level, what do those kind of courts do? They hear cases, right? I mean, so in every system, there's 3 levels. They might have different names. They might separate them out and say there's 4. But there's always that original or trial level, which includes that 4th level in the Texas court system, that appellate level, and then the highest court level. So yeah, even in Michigan, you might have the district court in Michigan, but then lower than that, somewhat, you might have traffic court. But still, if you want to go someplace to have your case heard, that's where you go. That's the level that you go to, that trial court level. Yeah.
Do they do all kinds of cases for like that they need juries for, or is it just certain type of cases that they?
It depends on who they is.
Well,
depends.
I'm supposed to, I have to find out today if I got jury duty tomorrow.
Okay, yes, and
So,
what court?
The 62B,
Probably district court then.
yeah.
So in the district court, it might be a variety of things. It might be a civil case under a certain dollar amount. It might be a criminal case. So then that opens up. It could be personal injury, auto accident, contract dispute. I don't know. I'd like to say that a lot of those type of cases end up being criminal misdemeanor cases, but it could be any number of things. So yeah, the district court and circuit court, they hear a lot of different types of cases. All right, then the Supreme Court, that top level within the state, also known as the court of last resort. Kind of rhymes. Again, if it has a U.S. constitutional claim, maybe it's going to the U.S. Supreme Court. But, on TV, it's, I'm taking this thing all the way to the U.S. Supreme Court, like it's something you get to do, right? But from your reading, you find out that in most cases you have to beg. There's this writ of certiorari. That's how you say that. Pressure and Friends mentioned that in conversation today. So you say, Judge, please hear my case. It's a really important kind that the U.S. Supreme Court should hear. And they could say, no. Right? We're busy. Got to golf. Got to do whatever. And not hear it. In other types of cases, maybe you do get to go to the U.S. Supreme Court. In rare cases, don't miss this, in rare cases, they're even the trial court. Remember, I just got through saying there's 3 levels, trial court, appellate court, and then the top court. And then I just said, in some rare cases, you can go right to the top court. So the Constitution, if you look at the fine print, says, if it's this kind of case, there's only one court that could really hear this kind of dispute. What do you think, even without even reading the Constitution? When do you think it couldn't be in one state court over another that you'd have to go to the U.S. Supreme Court?
Or the Constitution.
Right? It might be more than a U.S. constitutional claim in some kind of case. It might be about the U.S. Constitution. That's a pretty good guess. Yeah, if you look in the Constitution, it enumerates them. One is between states. Not citizens of the state, but if the states sue each other. I mean, it makes sense. Like, what if Michigan, there's something about angry Asian carps, and Michigan is suing Illinois or something, and Michigan's like, come on over and see our judges. We'll be cool. Which state do you go to? Federal court? Which federal court in which state do you go to? So in some rare cases, when a state is suing another state, or ambassadors is another one. So sometimes you can stay in Texas, sometimes you go to the U.S. Supreme Court. All right, and this is an example of what I've been talking about. There's the state court system, and then there's this federal court system where you have, again, the trial court, the intermediate appellate level. At the trial court level, it's called the U.S. District Court. In the middle, it's called the U.S. Court of Appeals. I think in your chapter there's even a map, and we're in the 6th Circuit, but I'm not going to ask you that. Maybe someday that'll matter to you, but for now. And then there's only one U.S. Supreme Court. They've been busy lately, some people getting off, some people dying off, bringing in new folks, women, the different mix. But there's still only a set number of them, and they're all getting kind of old, right? So they can't hear a whole lot of cases, right? So even when you look at this system, not even considering the concurrent U.S. claims in state court, what if every case in every district court funneled up through the different circuits to the U.S. Supreme Court? Yeah, it would take forever. If it was an issue of your life or death, it's probably not going to happen. So there's this writ that says, of all of these cases going through the federal court system or U.S. constitutional claims in state court, this one you really need to hear. What kind of things do you think would be important things that U.S. Supreme Court would want to hear about?
I mean, do a lot with death penalties. How do they?
Right. Well, why? One, because it's federal law, but a lot of times it's a question of constitutionality. What's the Constitution say about punishment? Can't be cruel and unusual, right? So somebody keeps trying that, and then they go to the U.S. Supreme Court and say, we know others have decided this, but this is really important because somebody's going to die. So they sometimes hear those cases. That doesn't mean they hear every death penalty case, though. Even then, if that's all they did, there wouldn't be enough of them and enough time to hear them. Yeah, here's a diagram. So Michigan, Ohio, Kentucky, and Texas, all within the Sixth Circuit, which doesn't mean a lot other than if you're in the federal court system and you're going to appeal, then you're in that circuit and you have to go to that circuit's Court of Appeals. All right, so more detail about how you get through state court. The plaintiff, remember I said the plaintiff is the one who's complaining, who says they were injured, files a complaint, and they serve it on somebody with a summons. Anybody ever been served? Okay, you don't have to tell me. I know one of you, and the odds are one of you has at some point in your lifetime, right? That serving you with the complaint and summons is due process, right? It's saying, hey, look, someone is complaining about something you did, and this court has jurisdiction, and you better answer and get there. And so the defendant might answer. The defendant might come back and answer the complaint and say, sure, this is the right court. Yes, I am that person, but the rest of what you said is nonsense. In fact, you injured me, right? Counter-complaint. Or before they do that, they might move to dismiss the case. What would be one reason why you would ask a court to dismiss a case before they even hear it? Wrong person. It's not me. You served me, but I'm not him or her. Jurisdiction, right? I mean, so far, of all the things we talked about, you could say, right person, wrong court. You don't have power to hear my case. Or perhaps there's just no evidence. That one, usually doesn't survive. Usually you end up having to answer. Then there could be some pretrial motions. Again, thinking about hourly rate of an attorney, creating all these pleadings, going to court, hearing getting adjourned, going back, costing you. It might be a motion for judgment on the pleadings. Look, judge, all you got to do is look at what's here and reach a decision. Don't even need a trial. Or you do need to make some findings of fact. You do need to take a look at the law, but you're not going to need a full trial here. It can be something shorter. Then discovery. Discovery is about finding out, discovering what the other side has against you. And often courts enter orders saying you have to reveal what you have to the other side. And you can discover what the other side has through these discovery tools. Depositions, oral testimony under oath before trial. Now, why is it if you're going to trial and they're going to testify under oath, you would want them to testify under oath before trial? Yeah.
What if you do go get served go for the motion for the judgment, and the judge end up making a decision, but didn't get a chance to look at the defendant's evidence, just went on here with the plaintiff. Could they go to the discovery, or could they ask for a trial or something to try to serve their defense?
I'm not sure I understand the question. So the plaintiff files a complaint. The other party does nothing?
No, the other party have as evidence that they don't
okay.
or bill or something.
Okay, so they don't bother to disclose the evidence that they have?
They do, but the judge don't want to look at it.
Right.
They just went on here with you owe this bill, so I'm
right.
looking at the evidence.
Yeah, I mean, that's a lot of times that's what people appeal decisions on.
So you can't
right?
appeal that?
Well, you could, whether it's the decisions are changed, you know. Let's say you say during trial, Your Honor, I'd like to introduce into evidence exhibit number 1, a contract between the parties from some other thing. And the judge says, it doesn't matter. I'm going to try to be generic and not answer any specific questions about a specific matter. So whatever it is, and the judge says, that doesn't relate, you're introducing it wrong, you're not following the rules, I'm not going to hear it. So decisions made, then perhaps that's one grounds to appeal the decision. I feel the result would have been different if this evidence had been considered and it was improperly excluded. Again, the higher court isn't like, bring me those medical bills or contracts or whatever it is and let me look at them. It's just looking at the legitimacy of that decision. And, you know, sometimes the appellate court says, well, it was within their discretion. Maybe they could have if they wanted to, but they chose not to. And, you know, sometimes the question is just whether that's prejudicial to the party who didn't get to introduce the evidence. So, mostly a question of law. All right, interrogatories. Written. Oh, back to deposition. I heard some people respond. You may want to get somebody locked into what they're going to say before they say it at trial. So that they say something different, that's a problem. Or maybe they're not available at trial. Maybe they're not going to live. Or maybe they're a busy doctor or whatever it is. And you want to, they're an expert of some kind. You want to lock in their oral testimony before trial. Interrogatories, written questions under oath. So admit that you were here. You know, that could be a request for admission. It could be disclosing information and they have to write out their answers and sign it. Again, you said this before trial, now you're saying this. You're not being consistent. You're not accurate. Request for documents. What do you have? Medical bills, contracts, other documents in the case. Or perhaps even electronic discovery. What emails were exchanged? What files are on this computer? So each party should have a chance to get that information. What witnesses are you going to introduce at trial? And in a lot of cases, if you fail to comply with this order, let's say you had some documentation you intended to introduce at trial, but the court excluded it because you didn't tell the other party about it beforehand, then that might be the sanction. You may not be able to introduce that evidence because you didn't disclose you were going to. All right, pre-trial conference. This is a place where you go to get ready for trial. How long is the trial going to take? How many witnesses you're going to have? What kind of evidence are you going to be introducing? But also, another purpose is to try to settle the case. Usually there's a lot of pressure on the parties of, do we really need to have a trial? What are the remaining issues, and can't we resolve this through some kind of settlement beforehand? Then jury selection, or voir dire, means picking a jury that's going to be fair and impartial. So one of the things you're going to want to know about them is how much they know about the case, how much they know about the law related to that kind of case, what kind of person they are, you know. Are they some crazy person that just got selected for a jury pool and has got all kind of biases? Or, you know, are they going to be fair and impartial? I never get to serve on a jury. There's lots of reasons to kick me off of them. I mean, just look at me. I'm white, I'm male, I'm a lawyer, former prosecutor, former defense attorney, whatever there could be. You got to get me off of there, right? Because I'm unpredictable. I don't know. So I'll never get to surf. But to all you lucky people who get to, have fun. All right. At the trial, opening arguments by the parties. A lot of people don't understand that the defense doesn't have to actually open. They don't have to make an opening argument. They can wait to see what the plaintiff will do and then see if they ever do it. I used to do that trick as a defense attorney. The plaintiff has said, ladies and gentlemen of the jury, we're going to prove blah, blah, blah. We have to because that's what the law is. And I'd wait, and then I'd say, you remember back when they told you they were going to tell you this, this, and this? Oops, they missed this. This is big. So then the plaintiff presents their case. Why does the plaintiff go first? They're the one bringing the case. They're the one that has the burden of proving. In a civil case, how much evidence do they need? You'll see it in the future, and you're going to go, "What? Where did this come from? What is it?" No, not in a civil case. That's a criminal case, beyond a reasonable doubt. How much evidence do you need in a civil case? Less. Very good. What's that called? Anybody? It's called a preponderance of the evidence. Preponderance. More likely than not. So it is a lower burden of proof. Some people say 51%. It's more likely you're right than they're right. And still, in a civil case, you've got to show the judge or jury that your side's right. And then the other party gets to cross-examine witnesses. Then a defense goes and presents their cases, their evidence through witnesses, other evidence. Then there's the closing arguments and like I said earlier, a verdict or a judgment. It says a motion for a directed verdict. There may be some situations where at the end of the trial or before the end of the trial, one of the parties says, stop here. Like the defense could say, remember earlier the prosecutor said they're going to prove these things? This thing's completely missing. Therefore, we want you to decide the case for us right now. Or it could go to the end of the case. And at the end of the case, the jury reaches a decision, and one of the parties says, Judge, the jury's crazy. Maybe not in those words. They have no idea what they're doing. They made an improper decision. They decided the wrong issue. We want you to set aside the jury's verdict. When might the judge do this? Understanding the judge has a lot of political pressure, and if there's a jury there of people who may have elected the judge, the judge doesn't like to say, you're right, they're crazy. But when might a judge say, I'm going to set aside that verdict? Right, they were told, don't think about this area of the law, and they did anyway. Or I've seen juries walk in and say, we find blah, blah, and that wasn't what they were even on trial for. Well, you can't. No one proved that case. So sometimes, or there's some kind of bias of some kind. A juror was paid off or whatever. One of the most recent ones I heard was one of the jurors tweeting the tweet was, can't wait to tell the defendant they're guilty. Whoops. And that got out. That's not good. So yeah, juries do crazy things. I used to walk through the courthouse and I could hear juries talking about exactly what the judge told them not to talk about. Well, I think he looks shifty to me, and he did it before, so I'm sure he did it now. All kinds of stuff. There's the post-trial motions. J&OV basically, like I said, means put the jury's verdict aside. Or a motion for a new trial. Something prejudicial happened to the defendant. Whatever it is, there needs to be a new trial. One of the tricky parts is often if you're requesting a new trial or you're alleging that the judge was somehow biased against you, guess who gets to decide that? The judge. You're like, Your Honor, don't want to offend you, and I know I got to practice in front of you all the time, but I think you're kind of prejudicing my client in this case. And the judge says, no, I can't believe you'd accuse me of that, and I overrule you. Of course, then you could appeal, but now the judge isn't real impressed with you. All right, the appeal. Of course, if you don't make the objection, then your client sues you for malpractice. But anyway, the appeal. You file the appeal. You point out what the lower court did in error. You go into the appellate court and argue your brief, and then there's an appellate review. And like I said, the appellate court doesn't bring in new evidence. They review what the lower court did, and they try to decide whether the lower court did it correctly or not. All right. Again, because we have to talk about cyber courts and cyberspace, there's been some movement to do some of this stuff online. Michigan hasn't been successful at having an online cyber court. In fact, it really is tricky. I mean, if you think about it, you'd kind of like to see the person face to face, judge their credibility. So actually having trials over the internet, not going so well. But electronic filing, your complaints, your pleadings, getting records of what's happened in disputes, that's more available. Seeing the court docket and what's happening next. You could probably go online, you hear a story in the news, probably go to that court and find out what's happening in that story. Another way online comes into play is dispute resolution, which is a little transition into the last part of the chapter. And, take eBay, for example. My father-in-law is staying with me right now, and he's always got an eBay auction going. He finds stuff at garage sales and sells it for like 10 times what it's worth on eBay. It's amazing. You can't sell stuff at garage sales, but people buy stuff for ridiculous prices on eBay. So, anyway, that's what he does. And if he has a dispute with somebody, like I remember one of his disputes, hopefully he won't listen to this recording. One of his disputes was he's a retired police officer, and he bought a GPS through eBay, and after he bought it, he got contacted by the Boulder Police Department saying that it was stolen. Apparently that's the way a lot of people fence GPS and other equipment is through eBay. And he asked me, well, what do I do? I've given this person the money. They've given me stolen stuff. Can't find them anymore. They're not giving me the money back. Should I give? I said, well, the first thing you want to do is contact the police and find out, are they really asking for it back, or is this somebody online asking you to ship them something that doesn't belong to them or something? So he verified that, and it was true. Basically bought something that was stolen, and he had to return it. At least it's now held in evidence. But if he had a dispute in that situation, he's already agreed by selling his stuff on eBay to certain terms, and one of those terms is if you buy something and you don't get it, or you get it, you don't get to keep it, whatever it is, eBay will say, we're just an intermediary, we're just an auction service. It's not our problem. And because you went through eBay, you've agreed to this third-party online dispute resolution service where you submit your claim to them. I didn't get what I paid for. I got it, but it wasn't what it was promised. And the other party does, and then they decide it, and then you're bound by it. You contractually agree to that in advance when you sell something on eBay. A lot of people don't know that. So sometimes that's good, right? For eBay, it's good. And maybe good for you because you get to go through this allegedly accelerated process and get the decision without spending a whole lot of money. So there are three broad categories of alternative dispute resolution. There's more, Like you could say, well, the chapter says there's mini trial and there's all these different types of dispute resolution. But the broad categories are negotiation, mediation, and arbitration. And there is a fourth thing that we've already talked about to resolve your disputes called litigation, right? But these are the alternatives to it. So, negotiation. If you're married or you have a significant other, you're familiar with the process of negotiation. Like my father-in-law always needs something to do while he's at our house. So in addition to trading on eBay, he's also building a artificial wall with a column in our house. Now, I don't know if you've got any insight into me from any stories I've told you, but I'm a practical guy. I don't see a lot of benefit to this non-structurally supporting column and false wall. But my wife, who I love dearly, thinks it would look cool. And we talked about that. I'm like, well, maybe we should spend the money on this. She says, no, I'd like to spend the money on that. Well, I know, but we really need to fix this. And you've wanted me to fix this. Oh, I know, but I really want this. That's negotiation, right? That's the process of, I'm kind of making this up. I could really care less, but let's just say that we're having a dispute over this, right? You know, I represent my side of the case, she represents side. We don't bring in a neutral third party to settle the dispute. You know, it just doesn't rise to that level. Let's say I even got an attorney and she gets an attorney. Right? It gets that bad. Still, if the two of us, through our attorneys, outside the court process, settle the thing, that's still negotiation. Don't be fooled by that. Because it's going to fool some of you. You're like, ooh, they got attorneys. It must be something else. But a lot of times, parties use attorneys to settle cases outside the court system. Or they start in the court system, but they're able to negotiate and settle it before they go through the trial process. So that's negotiation. No neutral third party. You know what I mean when I say neutral? Like somebody's objective, not for one side or the other. They hear your case, they tell you what they think. All right, mediation. You introduce a neutral third party. My wife and I can't work it out. We go to a mediator. The mediator is not hired by her or hired by me to reach a decision for us. Either side, instead they're neutral. One of the key things about mediation is it's non-binding. So the mediator says, I've heard everything you've had to say and I think this. Now, you'll look in the book and you'll say, there's such thing as binding mediation. You know what I say binding mediation is? Arbitration. So think of mediation as somebody else coming into the dispute, hearing both sides, and reaching a decision that one of the parties could say, I don't think so, and go on and litigate it. Okay. Now this is a little tricky because in some cases, parties are actually required to go to mediation while they're going through litigation. Like if you go to the U.S. District Court here, the federal court system, and you file a complaint and you've got a lawsuit going, one of the automatic things they do is enter an order sending you to mediation. Why? Why would they, if you've decided to sue and go forward and say you can't resolve your differences, would they send you to mediation? Efficiency. So save you money, save you time, maybe resolve your disputes, free up the court to spend its time on the really serious things. But in a lot of cases, what does that end up meaning? You have to go through the cost and time of mediation, you don't like the result, and then you come back and you go through the trial. In fact, I used to sit on the Kent County mediation panel for the circuit court here, and there were 3 attorneys. One would be plaintiff-oriented, defense-oriented, and I was the can't we all just hug and get along guy in the middle. This is not my personality, but it was my role. And, basically, one attorney would be like, I know the law in this area, and I think the plaintiff would prevail. The other would be the defense, and I would say, whatever you decide is going to cost you a lot to keep going. So we would all collectively render what we believed the court would end up deciding based on our experience in the law in those type of cases, and recommend to the parties that they settle and accept that result. But they didn't have to. But there was a court rule that said if you don't accept it and you go further, if something happens and you lose, you might have to pay the other side's attorney fees. So there was a little bit of a to get them to try to go along with the mediation results. All right, arbitration. Arbitration is the last one, binding decision on the parties. When I say binding, the parties are stuck with it. Usually, because like in the example up there of employment contracts, because they've already agreed in advance to be stuck with it. Look at your insurance contracts. A lot of people don't look at this, but it says if you have a dispute with your insurer, you won't sue them directly. You'll go to arbitration, and you agree to be bound by whatever that arbitrator decides. And that arbitrator just happens to make all their money from deciding these type of disputes, but, right? So, mediation, non-binding, arbitration, binding. All right. We'll stop there. Remember, you have a quiz over these 2 chapters. You can do it online before next class, or come to the next class and do it in class. If you come to class, you can bring your laptop, or you can use a laptop I'll give you. If you come to class, yes, you can use your book and notes. It wouldn't be fair for me to say you can use your book and notes outside of class, but if you come here, you can't.
Do we do our test before we